For those of you who don't know me, my name is Mark Loveday. I'm a barrister at Tanfield Chambers. I'm giving this talk with Gemma de Cordova, who is a colleague of mine in Chambers. It's one of a series of talks that are being given. I think this is the fifth that Tanfield has given since the lockdown started. And it's on the topic of opposition grounds under the 1954 Act. Just one or two housekeeping points. Firstly, this is going to be recorded and it'll be available on the Chambers website for downloading at any future date. So if you don't manage to stay with us until the end, you will get an opportunity to download it and read it and watch it at your leisure. The other thing is that we do have questions and answers, but I'm afraid this particular Teams format means that we can't hear what you're saying. So you can shout and scream as much as you want in the background, but we won't actually hear anything. But there is nevertheless on screen, and hopefully you can find it fairly easily, an opportunity to submit written questions, and we'll be looking at those during the course of the talk, and hopefully we'll start by answering some of those right at the very end. So if you do have any questions, that's the way to put them down. Just as stepping back, we live in interesting times when it comes to business tenancies. Not only the lockdown, which is the COVID-19 lockdown, which of course has changed the commercial reality of business tenancies across the country, but we were already in a slightly unusual position historically, and I keep an eye on the British Property Federation lease events reviews, and the 2019 lease review suggested that the average term for a new commercial letting was about 6.5 years, which is actually up on what it was about 6 or 7 years ago. But nevertheless, compared to many historical business tenancies, that's a relatively short period. One of the consequences of that is that there are very few rent review clauses in these, and indeed fewer break clauses than would ordinarily be the case. There's about a third, about 30% of business tenancies have break clauses, effective break clauses incorporated into them, and a relatively small proportion of leases actually renew on expiry. About 30% renew on expiry. And one of the consequences of that is there's a very high vacancy rate at the end, and something like 60% of premises become vacant on expiry of the lease. That doesn't mean to say, though, that business tenancy renewal isn't important, and it's an important tool, and knowing about it helps both landlords and tenants to negotiate around not only their occupancy and but also the terms, and in particular rents and so on, that are payable under the leases. On top of this, we've grafted the COVID-19 pandemic. We have prepacks, a lot of prepacks, widespread requests for rent reductions and other concessions, relaxation of planning, some already there, but some in the offing to enable conversion from commercial to residential, which adds an added angle to the commercial options available to landlords. And of course, we have the dreaded CPR Practice Direction 51Z, which effectively prevents forfeiture in the case of or possession claims from tenants in default. All of these play into negotiations, and as I said before, termination of leases forms part of that, and knowing about and being alive to the opportunities available to both landlords and tenants with termination of leases is an important part of this commercial matrix. I'm now going to pass, so we're going to really deal with this in a number of sections. First of all, we're going to ask the question about whether there is a business tenancy, then we're going to look at the associated issue of contracted out tenancies, which Gemma is going to deal with. I'm going to deal with the service of statutory notices and applications. We're then going to turn to the grounds themselves, and in particular looking at the S. Francis case and the cases that come up after that. So without further ado, I'm going to pass over to Gemma to deal with the first question, which is always whether there is a business tenancy or not. Gemma.
Thank you, Mark, and good afternoon, everybody. Because a starting point always needs to be in these cases, stop and take stock. Is there a business tenancy? Is this a tenancy to which the Act applies? Because I tend to find in my practice, it's often the case that something unconventional has happened, and therefore we need to have a think about that. The Section 23 tells us that the Act applies to any tenancy where the property comprised in the tenancy is or includes premises which are occupied by the tenant and are so occupied for the purposes of a business carried on by him. That ought to be a straightforward question of fact. Now, I want to start by taking you to consider some written agreements. Okay, great, written agreements. The case of London College of Business and Tareem Limited. This was a classic question of lease or licence. And in this particular case, the question was whether the college occupied the premises under a lease or licence, bearing in mind that they had entered into a succession of agreements which were on their face described as a licence to occupy. Now, in this case, Tareem had re-entered following disputes about charges for occupation and also service charges. Following that re-entry, there was then litigation to determine what exactly the provisions of the agreement had been and what the college were duty bound to pay in those circumstances. Now, despite what the agreement said on their face, i.e. that they were licence agreements, the High Court concluded that the college had been paying a termly rent, they had been given exclusive possession, and far from this being a legitimate determination of a licence agreement, what we actually had here was a protected tenancy under the 1954 Act. This led to damages being payable to the college as a result. So certainly a word of caution there. As we well know, what the agreement says on its face is not going to determine what a court may construe the arrangement between the parties to be. Another example of a written agreement is the case of Elliott and Whitney. That's a 2018 decision of the High Court. And this is a case which illustrates the problems that can arise when an occupier is let into premises, and then there are subsequent discussions and negotiations as to exactly what type of occupation that should be, but then the arrangements are not properly documented or properly reduced into writing. So this case just concerned a temporary weekly arrangement to occupy a nightclub in York. And the court was asked to determine what were the binding agreements in this case. Now, on the facts, there were some concerns about the procedural progress of the case, but once it came to a hearing, the High Court concluded that they were not satisfied that there had been an assignment out to the occupier's company, and therefore that did not provide the defendant with a defence to a claim for what was loosely described as rent. Now, although the court did not hear full argument on the point, it did conclude that it was unlikely that the first agreement, which had been entered into in 2011, gave rise to a business tenancy protected under the 54 Act. And the reasons that it gave for that were these. Firstly, due to the personal nature of the agreement, it was stressed within a particular clause in that agreement that the agreement was personal in nature, and the court construed that that was likely to mean that this was a tenancy. Sorry, this was likely to mean that this was a licence rather than a tenancy. Secondly, the court considered that the interim nature of the agreement, pending negotiation and entry into a new and full lease, was a clear indication against the parties having intended that the 2011 agreement was to operate as a lease. It was clear that the intention between the parties was that there ought to be a formal lease entered into at a later date. And the court considered that in any event, even if it had created a tenancy, it was for a term certain not exceeding 6 months, and therefore it would have fallen within the category of tenancies excluded from protection under section 43, subsection 3 of the 54 Act. So that's just a quick look at written agreements. Let's move on then to consider verbal agreements. The case I want to talk to you about is Barclays, Wealth and Aramis. That's a 2014 decision of the Court of Appeal. Here, the parties had entered into a lease for a 5-year term. It was contracted out from the protections of the 1954 Act. During negotiations for a new lease, the tenant held over. Now, after 16 months or so, the parties did agree to a new contracted out lease, but that document was never executed. So later, after 30 months, the landlord argued that the tenant did have a yearly tenancy. This was important because it would have impacted on how much notice the tenant was required to give. In the Chancery Division, the judge concluded that the parties' efforts to negotiate were half-hearted. He concluded that the parties were not in the throes of negotiation, which is a circumstance in which a tenancy at will might be construed. So, what did the Court of Appeal decide? Well, the Court of Appeal reversed the decision of the Chancery Division. The Court of Appeal considered the parties' intentions and therefore their contractual obligations, and concluded that they fell to be determined by looking objectively at all of the relevant circumstances. The Court of Appeal looked at the negotiations and decided that although that they were slow, those negotiations were never abandoned, and those ongoing negotiations confirmed that both parties had continued to work on the assumption that a new formal lease would be granted. So, example of verbal agreements and what the court might look at there. Moving on then to occupation. There's nothing new that has changed as regards occupation. It's usually a straightforward question of fact. The tenant needs to be in occupation of the premises in order for the Act to apply. What then about the question of business use? I take you to the case of Smith, Tyrrell and Bowden. That's a 2018 decision of the High Court. The Act, as we know, tells us within section 23 that business includes a trade, a profession or employment, and includes any activity carried on whether by a body corporate or unincorporate. And again, it is a question of fact to be decided in all of the circumstances of the case as to whether any particular activity constitutes a business. In the Smith-Tyrrell case, this was an example of a case where section 23(1)(a) was considered. So just to give a bit of background, Section 23(1)(a) of the 1954 Act enables the tenant to be treated as carrying on a business in their own premises, even though the business is in fact being carried on by a company in which they have a controlling interest. So effectively, Section 23(1)(a) removes the distinction between the tenant and a company in which they have a controlling interest. However, in the case of Smith Tyrrell, the court concluded that that subsection did not enable the tenant to be treated as carrying on a business in the company's own premises. So because the company had taken a subletting of the premises, the company was in occupation and the company also held the lease. So the court decided that that was not a case where Section 23(1)(a) applied. In that case, the company was controlled by the claimants, so it wasn't an appropriate use of Section 23(1)(a) in that case. It is important to look closely at arrangements such as these, because it's not uncommon, in fact it's very common, that a lease may be taken out in the name of a director when in fact the director's company in which it has a controlling interest is in occupation. So it's important to look closely at these sorts of arrangements so that one can be clear whether or not the Act does in fact apply. So what of contracting out? Now, contracting out, it's only permitted under Section 38A so long as certain prescribed procedures are complied with, involving giving notice and a written declaration. We're not going to go into the details of that today, but there are certain things that need to be complied with in order for a tenancy to be successfully contracted out. Now, the case that we've included as an example here, the Newen and Thomas van Staden case, involves the old Section 38 subsection 4 of the Act. Now, although it's the old subsection, it's still relevant as there are many tenancies which may still be excluded under this particular provision. So this was a contracted out lease, and the court had to decide whether or not it was for a term of years certain. And you can see on the slide there that the lease was from and including a particular date to a particular date, hereinafter called the term, which expression shall include any period of holding over or extension of it, whether by statute or at common law or by agreement. And so the court had to determine whether or not that form of wording was for a term of years certain under Section 38(4). The court concluded that it was, that on a true construction of the lease, the term was not for a term of years certain, and therefore it could not be excluded from provisions and indeed the protections under the Act. The next contracting out case that we wanted to highlight for you was the TFS and the designer retail outlet centres, the TFS being the fragrance stores or fragrance shop, I believe. Now, in this case, statutory declarations had been validly made despite ambiguities in identifying the commencement date of the tenancies. And the purpose of the requirement to set out the commencement date was to identify the relevant tenancy so that the tenant was able to confirm that it understood that it was entering into this particular agreement and that the protections would not apply to that agreement. So the question there was whether or not the statutory declarations, notwithstanding the absence of the commencement date, were valid. And the court held that the purpose being to identify the tenancy, it was sufficient. because it was sufficient that the tenant was able to identify and understand that its tenancy was excluded from the 1954 Act. And so for that reason, it was concluded the statutory declarations did meet that purpose. I should flag that there is an appeal outstanding on the TFS case. I checked on the Court of Appeal case tracker. It appears that the appeal date is listed on the 24th of this month, 24th of June. So we wait to see what the Court of Appeal decides on that appeal, but do keep an eye out for that. I'm going to hand back to Mark now.
Right, okay, great. I've got 2 or 3 slides here with questions, but actually I'm going to just quickly trot through the rules that apply. What I'm trying to illustrate is that the tactical use of the various time limits and so on can be very important indeed in the process of trying to maximize whatever commercial leverage you have over the other side to achieve the best result. The basic principles are fairly clear, although they were obviously modified from the original 1954 Act when it came to the reforms, which I tend to think of as relatively recent, but I think are now about 15 years old. But nevertheless, the basic principle is the landlord can serve a Section 25 notice terminating the tenancy. This can be either an opposing notice or a non-opposing notice, and the tenant nowadays doesn't have to serve any counter notice, but the tenant, or in theory the landlord as well, although the landlord will almost certainly never do so, the tenant must apply to the court for a new tenancy by the date specified in the Section 25 notice. And whether or not the landlord was prepared to agree a new tenancy, it doesn't matter. If the tenant gets it wrong and doesn't apply in time, that's the end of things, and it doesn't get a new tenancy. If it wants a new tenancy, it has to negotiate a new deal completely, usually at a higher rent. The landlord, if instead of the landlord serving a Section 25 notice, the tenant takes the initiative, it can serve a Section 26 notice seeking a new tenancy. The landlord can only oppose the new tenancy if it serves the grant of a new tenancy if it serves an opposing counter notice, and again the tenant must apply to the court by the date specified in the Section 26 notice, or it loses any right to a new lease. There is then the provision for landlords to apply to court for a termination order under Section 29. If it's given an opposing Section 25 notice or an opposing Section 26 counter notice, no matter which, as long as it's said it's going to oppose the grant of new tenancy, it can apply to the court immediately for a termination order. Those time limits can obviously be extended nowadays by agreement, written agreement, and then there are different provisions which apply if the tenant is occupying under a continuation tenancy. Those are the basic rules when it comes to termination under the Act. It used to be that there was a window that the tenant had to apply to the court, not less than 2 months or more than 4 months after the Section 25 or Section 26 notice was given, but the earlier of those 2 dates has been abolished, and there's only now a long stop date by which the tenant must apply. and there's actually, depending on whether it's a Section 25 notice or Section 26 notice, there's technically a 1-day difference as to the date that application to the court has to be made, but hopefully you won't get to that stage where you have to worry about that 1-day time difference. With termination, as I've said already, the landlord can apply to the court for a termination order, and the landlord's not usually interested in the latest day of applying to the court, but it can effectively apply immediately a notice. It gives its its own Section 25 notice or a counter notice opposing the grant of tenancy. So those are the basic provisions. Now, given that this is against the background of either the tenant wanting to stay on or the landlord wanting to terminate the tenancy, or obviously in the current environment, it may well be that actually it's the other way round. But nevertheless, that's the traditional position has always been that the tenant wanted to stay on, the landlord or wanted the tenant to go. And how does this the relationship between these time limits apply to affect the sort of tactics that you might adopt? Well, I've given perhaps the first question. Normally I'd throw this out to the audience and we'd have a little discussion, but I'm afraid this particular platform doesn't allow us to do that here. But the first situation which I normally look at in these talks is ask the question: if you're acting for a developer landlord who wants possession, perhaps you're fed up with your leaseholder having been approaching you during the lockdown period and asking for a lesser rent. You see the opportunity presented by the more beneficial planning regime, perhaps to introduce a residential scheme instead in place of the commercial premises. You want to oppose any renewal of the tenancy, and you're in a position to proceed quickly. You have plenty of funds, you have access to architects and surveyors and so on. What should you do to bring this ghastly situation to an end and crack on with your development? Well, you have a couple of options, but broadly speaking, you want to take the initiative. You will be thinking about serving your Section 25 notice as early as possible and opposing Section 25 notice, taking it on the chin that you're going to have to pay statutory compensation to the tenant. You'll be doing it as early as possible, and you will then have two options. You can either wait for the tenant to see whether the tenant bothers to respond to that notice, and you'll normally be serving a short dated notice, the shortest possible expiry period under your Section 25 notice. You're going to wait to see whether the tenant applies for a new tenancy. If it doesn't, that's end of story. You pay the stat comp and the tenant has to go. But you may well know already that the tenant is likely to try to string this out and try to frustrate this process, in which case you will follow your Section 25 notice with a Section 29 termination application to the court, hoping to get through as quickly as possible the termination, establish your ground of opposition, terminate the tenancy at the end of the term, and get on with your development. Hopefully, once lockdown is finished and the courts allow you to actually evict tenants, you'll be able to evict the tenant on once those proceedings have been completed. If you are for the tenant, let's have a look at the next position. What, say you're in the tenant's position, you want to carry on trading, you want to string this out as long as possible. Maybe you feel that you're going to get something more out of all of this development scheme than you would ordinarily be entitled to under statutory compensation, some sort of ransom payment for holding up the new scheme. You may feel that you want to carry on trading in your position, in your location for as long as possible. What are you going to do? Well, you may want to consider getting in as early as possible and serving a long-dated Section 26 notice, so preserving as much as possible that year of occupation. Leave it to the landlord to then respond with an opposing counter notice, and wait, pay the long game, apply to the court for a new tenancy at the latest possible date if the landlord hasn't got in there first. Slow things down, put the landlord to proof of its intention to redevelop, and speed. Once you get into court, speed things up as possible so the landlord is forced to early disclosure and to come to court in that way. So that's the response you would have from the point of view of a tenant to that situation. Question 3, you act for the developer landlord, but he cannot proceed with development quickly. What would the tactics be in such a situation? Well, in effect, you're going to be adopting the opposite. If you haven't got your funding in place, if you're not likely to be able to get an architect to draw up a development scheme, you're going to take the opposite tack, going to slow things down, long-dated notices instead of short-dated notices, leaving it to the tenant to take the initiative in terms of applications to the court and so on. And question 4, which is the mirror image of that, you guess the answer to that. It's obviously the mirror image of what they would have done under the second question. In other words, trying to speed things up, trying to trip the landlord up as much as possible, get into court as early as possible, get an early disclosure and so on. So you've got all of that. So that's what you do with notice. Just a brief mention of CPR 56. The general position is that if it's an opposed termination lease renewal, this has to be issued on Part 7. If it's unopposed, that can be a Part 8 claim. In London, unopposed or non-opposing applications are often now transferred to a judge at the first tier tribunal, property chamber, to be dealt with. Of course, that's the theoretical position under CPR 56. The reality is that applications to the court at the moment are not being progressed at all. We're not getting any hearing dates or any substantial number of hearing dates, although they are obviously beginning to open up a little bit. We're getting a few video hearings as well. I'd be interested in your experience with this, but certainly our experience in chambers is that the number of either opposed or non-opposed applications in the Central London County Court have really fallen to a complete trickle. So those are the procedural matters. I'm now going to move on to the various grounds of opposition. I'm going to deal with the easy ones. Gemma's going to deal with the topical and more difficult ones, so I can trot through the initial grounds, but it's always worth just reminding yourself every now and again of the full range of grounds, and just to see, so that you have them in the back of your locker, and it's not just 31Fs and 31Gs that you have in mind. Sections 31A to C I've put up there on the slides. This slide, just a summary. Ground 31A is disrepair. Ground 31B, persistent delay in paying rent, and ground C, other breaches of covenant, as grounds for opposing the grant of a new tenancy. And the reason I refer, it's getting on a bit now, but I always refer to Yusufi and Musselwhite, is that it illustrates a practical example of the Court of Appeal looking at all three of these first three grounds. I can tell you the answers to the questions here. In Yusufi and Musselwhite, there was creeper. The tenant had allowed creeper to grow on the back of the building, and the landlord couldn't even access the brickwork in order to carry out a survey to assess the condition. It was held that the cost of removing the creeper was only 350 quid, and this wasn't a substantial breach which was sufficient to oppose the grant of a new tenancy. Ground B, persistent delay in paying rent. There'd been an on-off problem with late rent and a small amount of arrears. The rent arrears were held not to be serious or a substantial breach, and therefore that wasn't a ground for not granting a new tenancy. But a refusal to allow the landlord access to gain access to and a breach of user covenant were held to be substantial breaches, which were grounds, the Court of Appeal felt, for opposing the grant of a new tenancy. So it gives you a useful idea of the way that this operates in practice. D and E, suitable alternative accommodation. Let's see whether I can go back. We have this. No, I can't go back. You see, you missed that slide. D and E, the suitable alternative accommodation. There are cases on this, many of them, and it really follows the old Rent Act, suitable alternative accommodation type grounds. And here we are. And E, uneconomic subletting. I think I've possibly done the only, well, certainly the only case that I am aware of that anybody's done on 31D. It is a tortuously complicated provision which relates to the rent achievable for renting separate parts of the holding. It really arises very infrequently and in very special economic circumstances. I doubt it will apply in the current market, but in any event, it's there. Which brings us on to sections 31F, demolition, reconstruction, substantial works of construction, and S. Francis. I'm going to hand over to Gemma to deal with that. Gemma.
Thank you, Mark.
Yeah.
So, ground F, this is our demolition, reconstruction, substantial work of construction ground, and many of you will be familiar with the case which has got lots of property litigators talking, the S. Francis case, and how we apply ground F now, grounds F and G, in the post-Francis world. So ground F, we need a firm and settled intention. This was well established, where the court said that it is not now in doubt that the import of the word intend in section 31F of the Act is that the appropriate date or dates there must be a firm and settled intention not likely to be changed, or in other words, that the proposal for the works has moved out of the zone of contemplation into the valley of decision. So what has Francis done to that? Essentially, Francis has given us a third strand of the test. I'll skip on to that slide now. Essentially, in summary, the proposed schemes in Francis, and the landlord did propose a number of schemes up until the date of trial. They were, in essence, completely destructive and made no real world common sense. The landlord undertook to carry out those works if no new tenancy was granted, but crucially, the landlord conceded that the scheme of works was designed with the material intention of undertaking works that would lead to the eviction of the tenant, regardless of the work's commercial or practical utility, and irrespective of the level of expense. Both the County Court and High Court agreed that the landlord had established a genuine intention to do those works. So this case went direct to the Supreme Court on a leapfrog appeal, and the Supreme Court determined that there was no real benefit to the landlord from the reconstruction itself. The value lay purely in getting rid of the tenant, and in those circumstances, the landlord's intention was found to be conditional. The intention to carry out the works was only conditional on there being necessary to get the tenant out. The Supreme Court determined that that was not the fixed and settled intention required by Ground F. The touchstone then of Ground F is a firm and settled intention to carry out the works. The landlord's purpose or motives are irrelevant, save as material for testing whether or not such a firm or settled intention exists. And the acid test, despite that lengthy quote there, it's essentially that final sentence. The acid test is whether the landlord would intend to do the same works if the tenant left voluntarily. And in Francis, it was conceded that they would not, and therefore the Supreme Court reversed the decision. So how does this apply going forward? How does this work now? There's been very little in the way of additional cases since Francis was decided. The Kendall Street decision is a key one, albeit that it's only a county court decision. In summary, there was a large building, and the landlord controlled possession of the basement. He decided to refurbish the basement, and as to the Ground F issue, the landlord decided to separate out the works so that it had a better chance of showing it could make out Ground F. That was in September 2018, so a few months before Francis was decided. So once Francis was decided in the early 2019, the landlord decided to revert back to do all of the works together in order to have a better chance of making out the Francis test. And at trial, the tenant accepted that there was some intention to do, the tenant accepted that there was some intention to do some of the works at some stage, but the tenant sought to challenge the timing and argued that the landlord was accelerating the works in order to try and make out the test for intention. The landlord did concede at trial that its decision to bring forward and combine all of the works was in response to the Francis decision. The landlord was concerned that its decision back in September 2018 to reduce the scope of the works would not satisfy the additional strand imposed by Francis. In any event, the court was satisfied that intention had been made out. Permission to appeal was granted in that case, but we understand that that case has since settled, so we're not going to get a review from a higher court of those particular circumstances. I've also given you reference to the Warwickshire Aviation and Littler Investments decision. That was a case decided in 2019. The landlord had everything in place. There were no difficulties with planning, timescales, etc. And in essence, the intention set out in Francis was made out for the whole of the scheme, as well as each individual element of the scheme, because that is what we take from Francis, that not only does the landlord have to demonstrate intention for the whole entire scheme, but also has to look at each individual stage as well. Ground G, briefly, there's a very large degree of commonality between grounds F and G. One can see the similar considerations are going to apply as regards the quality of the landlord's intention. I've given you brief reference to a section 31G case there. Again, it's a county court decision, but useful to illustrate how these things apply. The court accepted that the landlord in that case had a genuine and realistic intention of returning to the premises, comprising a flat, a barber shop, in order to live in the flat and participate in the business, albeit to a limited extent. The tenant sought to argue in this case that because the landlord was 85, it was unlikely that she genuinely intended to reoccupy, but the court was satisfied that notwithstanding her age, she would live in the property and she would have a limited role in the day-to-day management of the business. So given where we are now and the time, I'm going to throw it back to Mark, and he may have a brief word or two to say about compensation. But I think what we'll then do is have a look at, I can see at least one question has come in, and also Mark, it's an opportunity for you to share any thoughts that you have with us as to how the Francis test will apply in the COVID climate or in the post-COVID world.
Yes, thank you very much, Gemma. Hello, can you hear me?
Yes.
Yeah, good. All right. Look, just very briefly, I think really the 2 points, these two last points before we move on to questions, come together. I wasn't going to deal with compensation in any great length, section 37, but I was going to mention section 37A, which, although it's rarely invoked, there is a case on this, Inclusive Technology and Williamson. This is compensation available where it subsequently turns out that the landlord had withheld information which led to the tenant actually leaving, vacating the property in relation to section 31F grounds of opposition. Inclusive Technology and Williamson, basically the landlord failed to inform the tenant that it had indefinitely postponed the intention to carry out works. The tenant left in ignorance of that and then applied for compensation under section 37A because it felt it had been misled by the landlord. And the Court of Appeal held that it was that the landlord was under a continuing obligation to tell the tenant everything about its grounds of opposition and ordered compensation. Now that ties in very neatly with S. Francis, because it just reinforces not only the need for the landlord to be clear about its grounds of opposition if it's relying on redevelopment ground, and to form a subjective intention that is absolutely in line with S. Francis, but also to keep the tenant informed, because if it doesn't keep the tenant informed about its plans, it can end up with a section 37A claim and paying damages to the tenant as a result. So that's the lesson I would draw from that. Now, unless there's anything else, Gemma, I propose to deal with the first question that we've had. I'm just trying to see whether we've got any. We've only got one at the moment, and it may be that that's the only one we're going to be able to deal with.
Yes.
Somebody has asked the question, a tenant suspects a landlord wants to redevelop and still extract a dilapidations payment. What can it do? Well, it's very common, obviously, for a landlord facing the need to pay statutory compensation, a multiple of the rateable value for the property, once it's served a notice relying on section 31F or G, for the landlord to say, okay, well, I know I've got to pay you twice the rateable value or whatever, but I'm going to set that off against the terminal delapse, which amount to several times this, and therefore I'm not going to actually pay you any money at all by way of stat comp. Very common position to be in, and I'm sure those of you who act for landlords have often done that. The simple answer to that from the point of view of the tenant is that any set off, insofar as you can set off against statutory compensation, is going to be subject to section 18, the section 18 cap. So you need to get your section 18 valuer, or at least an informal section 18 valuation. And the point you're going to be arguing is the landlord would never carry out any repairs. It's not going to suffer any loss. There's no diminution in value because it always intended to carry out a demolition, and therefore there's going to be no therefore the section 18 cap will apply. That's the simple answer. If you're acting for a tenant, that's the way you deal with this threatened withholding of statutory compensation on the grounds that there are outstanding repairs at the property. Gemma, I don't know if there's anything you want to add to that.
No, Mark, I think you've dealt with that thoroughly. So I can't see any more questions as things stand. So I suppose it's just any final remarks on in this post-COVID or during this COVID world. Lots of things outside of our control at the moment.
Yes, obviously it is. One of the points here, I suppose, is that putting on one side that the economics has changed, and very often in situations where you wanted to get rid of a tenant, you'd be desperate to keep them, is that other tools aren't available. In particular, forfeiture isn't available for getting possession from a tenant, and therefore there is something to be said for if you are coming up to the end of the fixed term of the tenancy, from a landlord's point of view, to at least get the termination proceedings underway, which gives you a second string to your bow to deal with the market situation when we come out of lockdown and you can go back to court and get possession orders. So that would be a second way of achieving vacant possession. But apart from that, I don't have anything to add. All I want to thank everybody for listening to our Tanfield talks, and as I say, it's going to be available on the website for download. Thank you very much for listening. Bye-bye.